question I get asked very often as a property lawyer is, Tosin, what's the most important document when I am buying a property? And in today's video, I will be talking about that. So guess what that document is? It is the deed of assignment. And in this video, I'm doing a deep dive into everything that you should know about a deed of assignment. This is not a video to skip. This is not a video not to watch. If you want to buy real estate or you have bought real estate in Nigeria and you want to be sure that you follow the due process. Now, let me state that a deed of assignment could sometimes come with under the name of deed of sublease, deed of conveyance, deed of transfer. And why is it the most important document? When you buy a property, you want the ownership rights to transfer to you, isn't it? So the seller who was the owner before, upon selling the property to you, gives you the ownership right and you now become the new owner. That is what a deed of assignment does. And that's why you would say that it is the most important document when you buy a property. Let me also state that a deed of assignment does not apply when you inherit a property or you are given a property as a gift. This is specifically for purchase of a property. And the fact that you make payments for a property doesn't make you the owner. The law is very clear that it has to be via a legal instrument transferring ownership. If you make payment for a property and that's all you do, it's a very risky thing to do because you're not yet the legal owner. If you have to go to court, what are you going to show as proof of ownership? All right, it's very important that you pay attention to that. Now, typically, the law provides that every deed of assignment must be drafted and franked by a lawyer, and it is usually the buyer's lawyer. So, if you are buying a property, it is your duty to get the professionals who would work with you. And this is what I've talked about in some of my videos. Or you work with a lawyer, you work with other professionals. As a buyer, you should get your own professionals to work with you. You should not expect that the seller's professional would also act 100% in your interest. So you have your own professional on your own side of the transaction to protect your interest. So typically, it is your duty as a person or the company or the individual who is buying a property to ensure that you get a lawyer to work with you. Now, it's very important that it is not just about drafting a deed. It's important that the legal requirements are followed because if they are not followed, that deed is a worthless document and it doesn't prove ownership. It doesn't make you the owner and that defeats the entire purpose. All right. Now remember I said that a deed of assignment could be called a deed of conveyance, a deed of transfer, a deed of sublease. But how do you know which is which? It is the content that matters the most. Does it transfer title? Does it follow the legal requirements? And that can be determined by a property lawyer. Now, in this video, trust me, everything you need to know about a deed of assignment, I will be breaking it down. We will first look at what makes a valid and legally binding deed of assignment. I would also explain to you common mistakes that see people make when it comes to deed of assignment, and we'll look at expert tips for drafting a foolproof deed of assignment. Now, I cannot wait to get started, and I'm sure you are also. What should a valid deed of assignment contain? Number one, it should identify the parties. In a deed of assignment, we have basically two parties, the assigner and the assignee. The assigner is the seller and the assignee is the buyer. Now, let me state that there's something in law called proper parties to a contract. There are certain persons that cannot be a party to a contract. For instance, a business name cannot be a party to a contract. It must be a legal entity. It could be a natural person. For instance, a natural person means you and I. So we put our names are the names on that contract. Or an incorporated entity, which is an artificial person. That's an incorporated company, and incorporated trustees. And it's important to note that the way the names will be drafted, there are legal requirements that has to be followed. For instance, for a natural person, the natural person should use, I always advise that you use the name that you use on all your official documents for uniformity. Now, for an incorporated entity, for a company, the company should use the name as it is registered in with the government. And if it is an incorporated trustees, registered as an incorporated trustees, it should be the incorporated trustees of. and then the name. Okay, proper parties to a contract are very important. There, if a contract is drafted, a deed is drafted, and the parties are improper, the entire deed is invalid and illegal. It's very important to state that. Number two is the recital. Yes, the recital, and this is one very crucial part of a deed of assignment. There has to be the history of that property ownership. So, what's the history? How did the person who is selling to you, that's the assigner, how did he or she or the company or the group of individuals get ownership? That has to be in the deed of assignment. Another very important thing is clear description of the property being transferred. Typically, you should have done a survey plan, okay, and include the details of the survey plan in the deed. Because I mean, what's the essence of saying I bought this property, but you cannot identify it? Goes to no use. So it's important that the property is clearly described in the deed of assignment. Of course, the price is key. I mean, remember what I said about the fact that the deed of assignment is for purchase of a property, meaning that money is passing from the seller, from the buyer to the seller, and that has to be included. That detail has to be included in the deed of assignment. Another thing that has to be present will be the details of the ownership rights and the root of title of the assigner. Now, what type of ownership rights? How did the assigner, that's the seller, get to become the owner of the property? Did the assigner also buy it? Did the assigner inherit it? Did the assigner, was it a gift to the assigner? The details has to be there because there's something in law, in property law, that we call root of title. Title in this instance means ownership. You see, I cannot give to you what I don't have. So if, for instance, I am selling a property to you and there's any legal issue with my own ownership, if I pass it to you, you would inherit it. Let me tell you a short story so to really bring this back home. So a lady goes, for instance, and this is actually a real life story. A lady carries her mother's property documents and she sells that property to someone and disappears into thin air. Now, the property is not hers, and although she was able to get a hand of the documents and sell it to another person, eventually, when we went to court, even up onto the Supreme Court, because she was not the owner, she doesn't have ownership rights. The court held that it is her mom who is the owner of the property that still owns the property, and that new person who paid to the daughter does not have any title because the person did not buy the property from the owner. The owner on record is the mom. I hope we get the point. So it's important to establish the details of the ownership rights and the root of title in the deed of assignment. Of course, there also has now to be a clause that transfers ownership, all right? Because effectively, that clause is not there. Every other thing else that is there is going to no issue. Another thing would be covenants by both parties. So, what are the both parties agreeing with? Covenant is like a promise, right? So, what are the covenant? What is the promise from the assigner? What's the promise from the assignee? I'm trying to make this as I don't want to put in too many legal jargon so that we can understand. An indemnity clause, okay? The assigner should typically indemnify the assignee if there's another contrary claim to ownership. And you have the undertaking clauses too, all right? So typically there will be an undertaking clauses to say, okay, the assigner is going to provide all necessary help to help the assignee, that's the buyer, secure maybe a C of O or governor's consent to perfect their title, whichever one that applies, depending on the type of property and the ownership rights that they have. So you see, this is very important. Yes, signature. The signature is very important. Both parties have to sign. That's the seller and the buyer. And they have to have their witness also execute the document. So when we talk about executing a document, it's putting your signature on that document. So each party, the buyer, the seller, would also have a witness witnessing their signature. Please note that witnessing is not witnessing the document, it is witnessing the signature. So it's typically saying, yes, I know the assigner, his name, and I know that I attest to the fact that he was the one who actually put his signature here. So the fact that I call someone, for instance, to come and witness a document does not mean the person is going to then start to flip over to the beginning of the document and start reading. No, they are witnessing your signature. Yes. I remember I talked about being franked by a lawyer. Actually, without a lawyer's signature, seal, and details, the document is worthless. That's what the law says in Nigeria. So you need a lawyer who would sign that document, put his or her seal, and include the details. So I hope this is helpful. This is just part one. Now, let me add that it is drafted by the buyer's lawyer. It is an investment to protect the earned money you've worked for. So typically, it is a percentage of the price of the property that you are buying. It is an investment because without it, you actually don't own that property. All right. So if you are particular about safeguarding your interest, protecting your hard-earned money, this is something you should pay very close attention to. You should get the right person to work with you on. I hope that makes a lot of sense. Now let's look at common mistakes that I've seen people make when it comes to this deed of assignment. The first would be the property not being accurately described. And this is very, very fundamental. Like I said, you cannot transfer ownership rights in something that you cannot effectively describe. And that's why the place of a survey plan is very, very key. In the olden days, before the advent of survey plans and everything, what people would typically describe property with landmarks and say, oh, the land is bound on the right, maybe by a stream, and maybe on the left by one iroko tree, and But nowadays, we now have a survey plan that will pinpoint the exact location of the property. Another mistake I see may be made would be that some terms and conditions are omitted. And what makes a deed of assignment and effective as a legal instrument transferring ownership are those terms and conditions. We talked about 10, but we have a lot more than that. But those are the basics. It's important that all these terms and conditions has to be there. The covenant has to be there, or else it is a worthless document. Then not complying with legal formalities is another mistake. People would draft a document and doesn't have is not executed by the parties or is not franked by the lawyer. It's important that when you are working with your lawyer, make sure to discuss your terms of engagement and make sure that the entire transaction is formalized legally. All right, that's very important. Also, lack of clarity or ambiguity. Yes, this is also another challenge. An unclear history of title. Remember what I talked about the history of title? If there's an issue with the history of the ownership of that property and you buy it, you would be inheriting whatever legal issues originally applies to that property. So now let's look at the tips that we follow when we are drafting a deed of assignment, and this is what we typically follow at our law firm. First is we conduct a due diligence. It's very important. You want to buy a property, you do due diligence on that property. You get a lawyer to do the necessary checks, to do a meticulous review, to provide advice on the transaction and to let you know, is it safe for you to go ahead, is it not safe, what are the things that you should pay attention to. So that's the first step before you even go ahead to decide you're going to buy this property. Getting the due diligence done is very key. I'll leave a link in the description box below that talks about due diligence and what it entails. Now, typically, after that, if there is the due diligence has been carried out and everything checks out fine and is safe to proceed, we then go to drafting the deed of assignment. And whilst each deed is different, so each specific transaction is different, the history is different, the types of parties are different, the details are different. While we have some uniform clauses, but it's still each transaction is different from each other. So we typically have to get specific information about the property that you can use to customize each deed for the particular deed of assignment. After drafting the deed, we then have to review and revise. And this typically goes through more than a lawyer. So even if, for instance, my team, if a lawyer is drafting the deed or I'm drafting the deed, after I'm done, another lawyer is going to look at it. Why? Because we can't afford to make any mistake. This is typically like something that has to do with people's livelihood, people's life savings. So we typically have to review and revise to be sure that everything is accurate and all the clauses that should be there are there. And then we now go to proper execution. So typically, what I usually advise and which most of my clients follow is especially in instances where the client is making payment for the property 100% immediately, will ensure that the payment and execution of the property go pari passu. Meaning, as they make payments, the seller is there, the witness is there, the seller is signing, the witness is signing, the buyer too signs, and the document is properly executed. All right, and the lawyer also signs, and the seal is put there. All right, and then you can then go ahead to register the deed to perfect title. It could be perfecting title could be in the instance of a property that does not have a certificate of occupancy, would be applying for a certificate of occupancy, or if the property already has a certificate of occupancy, what we will be doing to perfect the title would typically be applying for governor's consent. So I hope you understand that. Now let's look at it. What's the consequence of a properly drafted deed? Now, if rubber meets the road and there's any dispute with regards to ownership of the property that you have bought, if you have a deed that is poorly drafted, you would not be accepted in court as proof of ownership. And you know what that means. You are not going to orally prove that this property belongs to you. How do you want to prove that orally? That's the essence of reducing it in writing and making sure it's documented. And when it happens that the deed that is supposed to prove ownership is rejected in court, that's a big challenge because the whole property, your whole investment is in is in doubt and is in jeopardy. So you really don't want to get caught up in this kind of situation. I'm so sure that you don't want to get caught up with that. And what's the benefit of a well-crafted deed of assignment? Peace of mind. Typically, you have legal protection, so you know that even if years to come or years to come, even if you've passed and you are in heaven and your children or grandchildren have inherited the property, because the deed is properly drafted, you know that it's yours and it's yours. And if rubber meets the road and you have to go to court, it will be accepted as proof of ownership. Let me state that the true proof of a document is, would it be admissible in court as evidence of what you want it to be accepted for? You draft a document and you want it to be proof of ownership. But when you take it to court, can it be accepted? I have been a litigation lawyer. I was a litigation lawyer for the first 7 years of my practice. And so I know how these things go when it comes to litigation and going to court. And trust me, you really don't want to get caught up with running around when you discover that your deed was not properly drafted. Okay, so make sure to get a property lawyer to draft your deed of assignment. It's important to get someone who is experienced in that field. Okay, so we have lawyers who will specialize in different areas. You want someone who is knowledgeable and experienced to draft the deed of assignment. And in case the deed of assignment was drafted by the other party, then you should have a lawyer review it. Just like I said, you should have your own professional on every transaction so that they can give you advice that is unbiased. Okay, that's very important. And at my law firm at Caris Legal Practice, these are part of the services that we offer. So if you want us to draft a deed of assignment, or you already have a deed of assignment or any property documents at all, and you want it to be reviewed, you can reach out to us. These are some of the reviews that we have from our clients. My law firm's name is Caris Legal Practice, and we rank number one on Google for real estate lawyer and property lawyer in Lagos. So you can always see these reviews, you can confirm them. This is another review and another review, all from clients who have bought properties and we have worked with. So trust me, you are in safe hands to work with us. All right. And please note that our services are for properties worth 10 million and above. So I will put a link in the description below. You can click it to reach out to us for our services, and we would be glad to work with you. If you have any questions, type them in the comment section. I will be in the comment section to answer your questions. And make sure to subscribe to this channel and check my channel for more valuable content like this on property transactions. I'll see you in the next video. Thank you.